Again, I'm Bobby. That's me in a suit. And make sure that I've got that screen. Sometimes my screen doesn't share properly. I've got it too. Okay, so screen share is on too. Good. And again, that what we do is estate and business planning. And I'm a very blunt attorney. Most estate plans don't work. Okay. How would you know if your estate plan worked or not? Maybe when would you know? Might be better after you're gone. And that's where all these things blow up and people get mad at each other, people suing each other, there's court, there's taxes. And so the goal really is to focus on what you want. And I think the best way to focus on that, I call it the snapshot test. I'm a very visual learner. And the snapshot test is all about is basically visualize a time that after you passed away, right? We got to do it sometime, right? And you're looking down from your cloud from above. All my clients look down, they don't look up. Beats the alternative, right? And if money is going where you thought it'd be going, right? And if people doing what you thought they'd be doing, then that's generally a plan that works. Okay. Money's not going where you thought they'd be going. People getting mad, people not going to the right place. Probably a plan that didn't work, right? And you probably have an idea of your snapshot. I'm going to make that snapshot hopefully clearer today, because a lot of people don't know their options when it comes to estate planning. I'm educating you today, okay? And so that's the main part of it, is just teach you what the options are. And most people come in and ask about the documents. What document do I need, right? Do I need a trust, a will, a power of attorney? And I'm saying that be careful if you go to an attorney and just ask for the document, in that you made that, maybe that's all you're getting. And so you have to think a little bit bigger, because when you've been in the business long enough, it's the documents that don't do the work, right? When I get the call from someone who's passed away, the family who's passed away, or when someone passes away and their family is dealing with it, the will is not jumping off the shelf and doing everything, right? It's the family that's doing it, okay? And they're going to figure it out. My analogy with this document item is, if you've ever seen the show, The Fixer Uppers, I'm a big fan of Chip and Joanna. If you ever had remodeled your house, they're basically someone that they come in and renovate the house. Joanna is the one who comes and sits down with the client, says, what's your vision for the house? What's the bathroom, the kitchen? How do you want it to look and feel, right? And then Chip is the carpenter who comes in with the tools and makes everything. So if you've ever had a renovation, if you ever saw that show, does anybody ask Chip what tools he uses to get, to make that happen? No, right? And so my analogy is the attorney's tools are our documents, right? How do you want it to look and feel? Like when someone passes away or there's a disability, is it going to be a mess? Is there going to be court? Is there going to be taxes? Or are we going to have things in order, just pushing things back, papers in the back quietly in the back offices? We're not on anybody else's schedules, minimizes taxes, and the family knows the plan, right? So that's, that's up to you. So if you're just looking for a document, that may be short-sighted. Maybe that's all you need, okay? And so my goal is to show you what is out there. One thing that you have in your packets that I did not mention to you yet are the handouts. So I have a handout called Selecting and Working with an Estate Planning Attorney. This I think is valuable. If you're in the market for an estate planning attorney, these are the questions I would be asking them. Okay, everyone asks about price. Don't worry, we'll talk about price. Okay, there's about 14 other questions you should be asking the attorney. Okay, and so I've given you the questions to ask them, and so to make sure they know what they're doing, right? I'll check back in later and tell you what our answers. I mean, you'll through the program, you'll see our answers, but this arms you with the education to do your own due diligence and see what you want for your planning. Okay. I see a question. So, okay, so good. So I had one question saying, I have 3 years away from retirement. A lot of our clients are 3 years away. I mean, are very close to retirement or in retirement. That's when people start really thinking about estate planning. You might have done like a simple will when you had your first child, or if you had, got married or something. And then you really start getting serious when you get older, when you there's an age when people realize that they're mortal. Oh, and so at that point, really people start focusing on that. And so there's and I have some questions. Most likely the answers I've heard from them is not accurate and probably wrong. So hope you can help get my wife and myself get some accurate. Yeah, I'd be happy to do it. You know, in my field, and we can talk about, we can open it up later. You know, in my field, I love what I do because it's so challenging and there's so many different areas. Because when you're talking about estate planning, I'm talking about families and all their wealth. Okay. And there's just so many different financial products and things that are out there, retirement plans, non-retirement plans. There's different rules and regulations for all those things. I'm the nerd who likes that stuff. I don't know why I like it. Okay. So that's like the retirement plan rules. I'm very familiar with those. I have a background in that. You know, I have a CFP certified. I'm not looking to do your financial planning, but I have that background that's there. And I like to work with advisors with regard to those types of things. So I have that, hopefully I have that knowledge. And if I don't know the answer, I can know where to find the answer. So hopefully I can give you some clarity today with regard to the retirement questions. Here's some typical traps too. Okay. You know, people are saying that, hey, I don't have a big estate. And so I don't have to worry about taxes or estate taxes. So there's no need for planning. That's short-sighted. And I'll show you today that there's other issues when it comes to estate planning, just than the tax side of things. Okay. What if you become disabled? Okay. What if you have a stroke? Has nothing to do with taxes, but it's a big deal for your family and for you, right? And so we have to figure out how to deal with those issues. Or the transfer trap. I just want to avoid probate, okay? And so people, you know, this thing about probate, some people are, probate is basically just a government audit of your affairs after you die. I think it's the old way of doing estate planning and estate administration. Because you can completely avoid it. And so that's a good benefit to have, but don't be so short-sighted that's the only thing, because there are a lot of other issues to deal with, right? And so my goal today is to show you those other issues and make sure that you understand why I'm explaining that. So again, what's really missing, I find, in all of the estate planning, like rather than go to LegalZoom, which you're welcome to go to LegalZoom, it's an online service for estate planning, okay? But you're just getting documents, okay? You don't have anybody who's actually counseling you on your options, where we had that question where someone's saying, I'm getting these wrong answers, right? That's the key, is getting with someone who's going to help your family steer you in the right direction. Which options do I pick, right? What's right for me? And so every family, I find, is a little bit different. And so you'll look at it. This part of it is more of a slide to say, this is how your picture might look. It's fuzzy. My goal is to get that to be clearer. So I'm someone who likes to start with like the basics. So if you don't remember anything else today, I would say, remember this is the definition of estate planning. This is one of the first questions I would ask an attorney if I was looking to interview them for estate planning. It's like, how do you define estate planning? And so it's not something that's in Webster's dictionary or Black's Law Dictionary. It's every attorney's own definition. I like the one that we use. It's from the National Network of Estate Planning Attorneys. I'm an instructor there. There's about 150 of us across the US that just do estate planning, okay? And so I think this definition covers all the issues. The main thing is covering the issues. And so this definition goes like this. I'm going to control my property while I'm alive and well, right? That's not an issue. Most of my clients, yes, no, there shouldn't be any change to your plan while you're healthy. It's really, estate planning is about contingency planning, right? So then a plan for me and my loved ones if I become disabled, mental disability. And then I want to give what I have to whom I want, when I want, in the way that I want. And I find people don't know all of their options of the way that they can leave their assets. And we'll talk about that today, okay? And then all while assuring my wisdom is transferred along with the rest of my wealth. I want to try to pass on that non-material wealth if we can, and like your values, your life lessons and stories, if that's something that's possible. And so that's the definition of estate planning. So our approach to that definition, how we work with clients, is we just have this kind of planning pyramid counseling philosophy where once I am engaged with a client, I'm going to start with this base of the pyramid, get to know your specific situation. What are your goals, hopes, fears, and concerns? Where are you at in life? Are you 3 years from retirement, right? Are you in retirement? Are you just wealth building mode right now, right? And then I want to learn about the family, right? What kind of family dynamics are there? Are you married or not? If you're married, how is the spouse with finances? How are your health together? Like if something happens to one spouse, will the other spouse know where all the assets are, or the bills and things of that nature, or they're going to be clueless, or are there health concerns there? And what about the kids? If there's kids, are they minor children or are they adult children? Whole host of different issues for minor children than we have for adult children. If you're minor children, then we have to worry about where they're going to stay, how the money works for them, and issues like that when they're adults. Age doesn't necessarily equal experience, I found. So do they need help on the investment side as well? If they're married, how are their marriages? Strong, shaky? Do they have creditor issues? How do they get along with one another? Do they have any health issues or special needs issues that we have to be aware of with regard to that? So, and then once I know the family dynamics, then I can show you strategies to preserve wealth, expand wealth, save taxes. But I need to know what your goals are and what you've got currently, right? If that makes sense. So that's kind of our process, how we meet that. And my basic idea is that you teach me about the family, we'll teach you about the law, and together we'll make the plan work. Okay. Here's the key. This is another important slide. So when I get asked to review a plan, or if I'm telling people, if you got these covered, you're good. So if you have these 4 bullet points covered, the last one has a couple of subparts, then you've got a good plan. Okay. Did you get good personalized counseling on your first plan? Yes, I spelled it with 2 L's to make a point. Did they give you some advice based off of your situation that's concrete, right? Or they just give you some word process documents and they got some biographical data from you and spit out some forms. So I can tell that if I look at the form, look at your plans and the like, and ask questions about to the clients. And then number 2 common pitfall is and we'll talk about counseling. I'll show you counseling issues in I'm going to magnify this in the later slides. Proper asset ownership. Number 1, probably common pitfall with the estate planning side, because this is the tedious part. Because when you think about estate planning, I'm really making sure that I've titled all your assets in such a way on major life events, death, disability, like we can transfer those assets to the next person in line with the least amount of hassle, least amount of taxes, no court, and get to the assets where they need to go. And it's all about asset ownership. So I know that, title different things in just different areas. And so there's only 3 ways you can own your assets, okay? Your individual name, jointly, and by contract. That's it, okay? And so people get confused on some of those, and we'll talk about that. Number 3 is have a formal review process, right? Have an agreement, take a look at this every so often to make sure it's updated with the laws and your situation. I'll show you what we do on that side. And then, is there a controlled transfer process, right? And so I'll get blunt again. I mean, this is probably, you wouldn't be wasting your time probably talking to me or listening to this if you didn't care how things kind of played out. You didn't want to mess, right? And so the goal here is that we want a controlled transfer process. And so to get blunt, I'd say, if you were to die today, right? Something happened to you today, how prepared is your family if something happened to you today? And that's what it comes down to, right? Would they have any idea what to do, how to do it, and how to pay for it, right? Usually death occurs, some people can't even find the will or trust or documents. They stumble into the lawyer's office, they're in the grieving process, they're one-on-one with the attorney, he or she's charging hourly, and things aren't sinking in because you're in the grieving process and it's taking forever and it's expensive, and people are like, why is it so bad? Because it's not that process is not a good process. It's a very reactive approach. And so I'll show you a better way to do things on that end. Okay, so there's 5 options out there in the world for you. Okay, so if you're doing estate planning, here's what I see as the 5 options to do planning. You can do no documents. I don't recommend that. We'll talk about that. You can do what's called a will, a simple will, and a POA stands for power of attorney. I'm sorry we have acronyms. Attorneys use these acronyms. But the power of attorney, hold on, there's a question. Are you going to be sharing the recording of this presentation with us? Yes, it is being recorded. If you ask Michelle, she'd be happy to forward it to you. I have no problem with that. Education is good. POA, power of attorney. And so a will, a simple will, and I have a lot of engineer clients, a will equals probate. So if you have a will, which is fine, that's the centerpiece of your plan. That means that the family will go to probate. I have one client, I have a will, I don't have to go to probate. No, that's ensures probate, okay? And that's fine if that's what you want. I don't like to go to court, but it's your option. POA stands for powers of attorney. There's 2 flavors of these powers of attorneys. There's financial powers of attorneys, and these are powers of attorneys that are dealing with designating an agent to make financial decisions for you, okay? Versus a healthcare power of attorney, where you're designating an agent to make healthcare decisions for you. And there's different flavors of powers of attorney. So financial powers of attorneys, even, then there's two different subcategories of financial powers of attorneys. You can have what's called a durable general power of attorney, or you can have what's called a springing or limited and miscellaneous power of attorney. What's the difference between the two? And why do you care, right? The durable general power of attorney is effective when you sign it. The limited and miscellaneous or springing power of attorney is only takes legal effect after you become to be disabled. Do you see the difference? One, the agent can take the money now. The other, you have to be disabled first. All right. So you have to understand the nuances and the differences between those. And then the healthcare power of attorney has different issues as well. Okay. And so we'll look at that a little bit too. So that's will and power of attorney. Okay. You can do a will with a testamentary trust and a power of attorney. So what is that? So stay with me. Last will and testament. A testamentary trust is a trust that's created after death. I'm not a big fan of those because I don't want court oversight of my trust. Why? That's one of the things I'm trying to avoid. So I'm not a big fan of that. Simple trust, you can do one of those ones that you can get off of LegalZoom or something where the attorneys are marketing it for $2,000 online that say, here's a trust, and they don't even meet you, right? And so that's very little counseling that I found, word processed. I'm not a fan of those. Those are options. And then I call what we do is really the modern approach. The documents are just part of it. It's our process, right? Someone dies or there's a disability, call the law firm. We got the process in place to get you through that, right? That to me is people don't care about the documents. Yes, they're important. You'll understand them. You got them. But they really just want to help their family get through that difficult time. And I find these individual ones, these ones in the middle are bare bones planning. It's the bare minimum, which you're entitled to do, right? You can do whatever you want. I'm giving you good, better, and best, okay? No documents is no planning. And I find the modern approach is the way that we resonate to. We're more of a relationship-based approach with our families. So those are the ways to plan. Here are the challenges in the estate planning world. Mental disability, biggest issue I would say today, right? To be blunt, when you're dead, we don't have to figure out, there's less of administration on your side, right? If you're disabled, then we have to figure out where you're going to live, right? Is it at home? Is it an assisted living facility? Is it in a nursing home? What kind of care you're going to get, right? The level of care that you're going to get. Where's the money coming from? It's outrageous. The expenses on the medical side today, just 1 month in a facility, right? In the Northern Virginia area, you're looking at anywhere from $6,000 a month to $20,000 per month, depending on the level of care that you have, right? And that blows through people's retirement. It's just crazy how that happens. So there's things that you can do to plan ahead for that if if you think through it. So mental disability, big deal. Asset transfer on death, right? Making sure that when there's a death, we don't have to go through a bunch of legal hoops to get the assets to the right place. I don't want to have to go to court to do this, right? And then the other challenge is taxation. Of course, we're going to minimize taxation to the greatest extent possible. And then personal planning goals. We want to make sure we achieve those, and I'll show you some examples of that as well. So those are the major challenges that I see out there. Our approach, it's not the only approach that's out there. I like ours. I've been doing this on this model for about 15 years, is a 3-step approach, okay? And the idea is we want to empower your design. So we want to make sure your design is the best possible, that you got counseled on it. So did you develop your plan with counseling-oriented planning partners? So we're counseling-oriented on the attorney side. Oh, you got this IRA here, you got this goal here. Let's figure out how to get things in order, right? And if you have a financial advisor that you work with, that's great. That's helpful. It's not required, but we'll work with them, okay, to make sure. If you got a tax advisor that you trust, I'm fine being a teammate with them. I find that makes everything, and makes your plan stronger, okay? And then number 2 is maintaining the plan, okay? So empowering that legacy by maintaining that plan, having some check the vitals every so often to make sure we're on track, so that when something does happen, we can secure appropriate assistance to transfer your wisdom along with the rest of your wealth. So I'm going into the engagement with my clients expecting to do the administration, okay? And I know people might be thinking, how old is this guy, right? I have more clients worried about my health and welfare than I've ever had in my life, right? I have no problem telling them my age. I'm 51. But I've got younger attorneys that are part of my succession plan that I'll show you when we get into the fee side of the discussion. So that's it. Those are the 3 steps. So let me give you some more education and kind of walk you through how we work with clients. So those of you who don't know about probate or only want to avoid probate, here's how you can do it. I'll teach you how to avoid probate without even seeing an attorney, without any legal documents. Okay, so if that's all you want to do, here you go. I'll give you the blueprint. So if your only goal is to avoid probate, here you go. First, you need to learn the basics. Engineers, I work with a lot of engineers. They love formulas, right? So anything that you own in your individual name at death, that equals a will, that equals probate. Okay, so think about anything you own in your individual name, that's all going to go through probate. All right, so that's the first set. All right, so let me tell you how you avoid probate. You can title things as joint tenancy, joint bank accounts, right? Joint tenancy with that thing called survivorship. That's a legal way that you hold title to assets. What does that mean? So if I own a bank account, a joint account with someone, let's say this is a spouse or my brother or things of that nature, when I die, by operation of law, that asset will go outright into that surviving joint tenant's name. They only got to bring the death certificate down to the bank or the investment company, boom, okay? But let's say we're in a married couple situation, right? So, okay, we titled everything jointly. Okay, on the first death, not so bad. We've titled everything jointly there to avoid probate, if that's all we're trying to do, and I'm just focusing on probate. What happens on the second death, right? So are we going to just basically let the surviving spouse try to figure all this out while they are dealing in the grieving process, rather than just set it up right the first time up front? No, let's just kick the can down the road, let them try to figure out when they're not probably going to be thinking straight, right? So let's just do that right now. And if you're just going to add on somebody else to those accounts, be careful, because when you have a joint account with someone, that account is exposed to all of their creditors, their ex-spouses, right? All of their baggage that they have, right? So not a great way to do it. And they have access to that money. They can take the whole account. I'm not saying they would, but it's not a great way to do the planning, okay? You can also do what's called these transfer on death accounts or payable on death accounts. That's the bank or financial institutions form. You read the fine print, and I don't like their contracts, but it says when I die, it goes to these people. Okay. What are you giving up? There's some protections there you're going to give up. I'll tell you in the next slide or 2 slides down. And then planning with the box. The box is in quotes. So if any of you have 401ks or IRAs or life insurance, you had to fill out this box, right? That said beneficiary debt. Who's your beneficiary? That's what I'm talking about. Okay. And so that might cause problems as well, because you don't really leave instructions with regard to that. So let's see how we can kind of develop this and figure out what the better way to do it. So here's what real world issues are. Okay. Here's how things occur. And that's what I find. This is not the exhaustive list, but these are common lists that I routinely go through with our clients' real personal planning goals. Okay. We talked about disability plan. I'm not going to talk too much more about it, but that's the #1 issue that I find. There's remarriage protection. Talk about that. Creditor protection. A lot of people are interested in creditor protection. Divorce protection, values promotion. So let's take them one at a time. Like I told you before, disability planning, the main thing there I find is that people haven't thought through the issues. And somebody said, yeah, I've got my disability plan all set up. I created what's called a healthcare power of attorney or an advanced medical directive. So remember I told you about that? That is one of the legal documents that we use, but that's not a plan. That is just a tool. An advanced medical directive is a document designating your healthcare agent to make medical decisions for you, but it's boilerplate. Okay, it says you can check me into a hospital, you can check me into a nursing home, you can keep me at home and bring home care in, you decide, right? And I'm thinking, if it's that important to you, where in your legal documents does it say what your wishes are, right? And so it should be somewhere. Like, I want to live at home. You have money to put things to lower the countertops, make arrangements, and then I don't want to go into a nursing home if I don't have to. Or I like this facility here. I've checked that out, right? So put those instructions in there. And I'm saying, if you don't care where you are, if you're in a disability situation, you're not doing your family any favors. It's more of a burden to them. Okay. I had personal experience, so I know this. When my dad got this disease called Lewy body disease, it causes dementia. And it wasn't like a 1-year deal, it was a 10-year deal. Okay. And I'm thinking, the first few years he was kind of with it, but years 7, 8, 9, it was the quality of life was minimal. And I'm pretty sure if we had that conversation with him, he would have said, don't want to burden your mom at this point. But I don't know. We never had that conversation. So to me, I think a good conversation with your healthcare agents will go a lot further than any legal document. Of course, we're going to do both and give you the right legal document and facilitate that conversation, because there's no black and white with healthcare decisions. There's gray areas, and it's really hard to make those decisions if you don't have an idea. The goal is for us to put you in as good a position of what that person wanted in that situation. Okay. And then that's just the healthcare part of it. What about the money, right? So, our clients are very big into control. They don't want to lose control of their money and how they have control of it. But let's say you're in a situation where you have dementia and now people are taking advantage of you. And the hard-earned money that you created is now going out the door, and spouses or family are not, they're losing, they're not able to get right to that, and that they're losing out on that stuff. And so is there a way to protect against that? So our approach to disability planning is just focusing on 3 questions. Okay. When am I disabled? Who do I trust managing my money when I'm disabled? And what can they use the money for? Okay, so most definitions of when you're disabled is when 2 doctors anywhere in the world say you're disabled, you're disabled. I don't like that approach. Okay, it's just like a cold, it's not a cold clinical decision. You don't wake up one day and have Alzheimer's, right? And so I want the family to be part of that, or friends, or someone that that trust. And so yes, we need a medical component, but we should also have, maybe if there's a married couple, maybe the spouse and the doctor talk about that, right? Or maybe the kids, if they're, or a friend that's involved that you trust with regard to that. So, our clients are big into control. They say, I want to be the one making the decision when I'm not in control. Unfortunately, you're disabled. Like, the next best thing I can do for you is give you control on how you give up control by defining when it happens, right? So we spend some time on that. And then you say, who do I trust managing the money, right? Who pays the bills? And then what can they use the money for? And I'm not going to give you a blank piece of paper saying, tell them what you want. We've done this before. We have checklists to kind of work you through that. And so that's, to me, is a very important item. Now, for those people who are worried about catastrophic illnesses that are blowing through people's retirement, and someone going into a nursing home, like I said, the expenses could be, $10,000 a month, $15,000 a month. And so there is something called Medicaid, that is a program that is administered through a federal program administered through the states, that is the only government payer of like nursing home care and some waiver care for home care. It is the last resort. You do not want to be on Medicaid. Okay, you don't want to Medicaid vet. But if that's the only place you have to be, and then the money is going out the door, there are things you can do to position your assets using trust to qualify for Medicaid and the like. I'm not going to go into all those details right now. This is not a Medicaid program. We know how to handle that, but that is an issue to be aware of. Okay. All right. So that's disability. Sorry about that. Remarriage protection. I don't spend too much time on remarriage protection. On remarriage protection side of things, the issue is this. So I'm going to introduce you to my favorite cast of characters, Bill and Mary Sample, and they have what's called the I love you wills, right? The I love you wills are very common. It says, and let's say they have 2 kids. So when Bill dies, everything goes to Mary. When Mary dies, everything goes on to the kids, equally common. If Mary dies before Bill, goes the other way, right? So I'm talking about remarriage protection. So let's say, and I always knock off the husbands first. Sorry, it's just statistics. So Bill passes away, leaves everything to Mary. And let's say Mary gets remarried, right? She meets Bo, the tennis pro, and they fall in love and they get remarried. And let's say Mary's will says everything goes down to the kids. Even though her will says everything goes down to the kids, does Bo have a legal right to those assets? Absolutely. In all 50 states, they have different rules in each state. In Virginia, he could say, I don't care what her will says. I'm taking my statutory 1/2. Now, it's on a graduated scale. So if they've only been married for a year or 2, they're not going to get the full 1/2. It's on length of marriage. You'll get eventually up to 1/2 of the assets. Maryland, you got 1/3. Most of the states are going to this family law type of way where If you've been married a certain number of years, like over 5 or 6 years, then you're entitled to half of the assets. Doesn't matter what the will says. Okay. And then another point is most married couples, how do they usually own their accounts? Usually joint accounts, right? So remember, I was teaching you about asset ownership. And a key point, if you're taking notes, is the way things are titled will trump the legal documents. What does that mean? Title trumps the legal documents. So if there's a joint account and the will, let's say Mary is married to Bo and they have a joint bank account, but Mary's will says everything goes to the kids, that joint account is not going through the will. It's going to Bo if she dies first. The bank institution doesn't care what the will says. A joint account going there. Who's usually the beneficiary of an IRA, right? An IRA retirement plan. In a married couple situation, it's usually the spouse. So if Mary put Bo's name on there, they're not going to go to the will. They just go, there's the name. We're going to give them money there, right? So if there was a way that Bill could leave his assets to Mary and she could use it for whatever she wanted, and when she passed away, it had to go down to the kids, is that something that's worth spending some time talking about? Is that counseling? Is that word processing? So I'm trying to show you, there's counseling issues that someone needs to be aware of and address with you before finalizing your plan, right? Doing your plan. Creditor protection, I think, is an important one to kind of spend some time on, because there's a lot of misconception on what trust can do. Revocable trust and asset protection, people just don't understand how they work. Okay, and I don't blame them, because it is an arcane area of law. So the creditor protection goes like this, and I usually tell a story to explain stuff. And I have my school bus story. So in this school bus story, there's two assumptions. Okay, so let's say that I'm dead. I'm assuming I'm dead in the story, unfortunately, and there's no creditor protection for me while I'm alive. Okay, so I've died and no creditor protection for me while I'm alive. And so I passed away. And let's say my spouse is all distraught. She's driving down the road. She runs a red light. Bam, hits a school bus full of kids. Let's say horrible facts. Let's say one of the kids dies. She hates herself. The world's against her. There's not enough money in my estate to compensate for hurt and killed school children, right? It's going to wipe everything out. So I'm going to show you there's a couple different ways I could have left my assets to my loved ones and show you the different asset protection features. Now, one of my clients said, Bobby, don't say hurt, killed school children. Say school bus full of lawyers. That'll be better. And so, with the lawyers to pass away, right? You can say plaintiff's attorneys that would be doing that. So the point of it is there's a catastrophic creditor that's out there. Okay. So the first way I could have left my assets to my spouse or my kids, it doesn't matter. I just use the spouse in the situation. Is I could say, when I die, I'm going to do a simple will, and I'm going to leave everything to my spouse outright. So when she receives the assets outright, she hits the school bus. Everything I've left to her is gone. Okay, those are all subject to her creditors. Second way I could have done everything is I could have just done everything by jointly titling at things, right? Oh, we're going to avoid probate. Great. So I die. By operation of law, everything goes outright in her name. The house that used to be jointly held is now in her own name. Now the creditors can put the lien on the house and take the house if they want, or they can take the bank accounts. They can garnish the bank account. So the joint accounts give you no asset protection. Okay. Third way is by contract. Let's say I had a life insurance policy that was worth $1 million when I died. Wasn't worth anything when I was alive, but when I died, $1 million. I wrote her name on the beneficiary designation form. She gets that $1 million check, puts it in her bank account, gone. Okay, subject to all of her creditors. Fourth way is you do those simple trusts, those bare bones trusts with very little counseling, right? And it says after I die, everything goes out right to my beneficiaries. All that stuff's gone. Okay, so let me pull myself out of the grave. Let me do my planning again. Let me do it this way. What if I did it this way? I can leave my assets to whoever I want. They can use it for whatever they want. But if they hit the school bus, it's protected from their later creditors. So let me say that one again, because that's an important one, right? They can I can leave it to them. They can use it for whatever they want. They have creditors. They hit the school bus, not subject to their creditors. Interesting, right? So I want you to connect the dots. Remember, I was talking about that definition of estate planning, right? And so my question to you is, how many of you would like to leave your assets to your loved ones that way, protected from their later creditors, right? And have you been asked that question before? Counseling, word processing. So remember that definition. I want to give I want to control my property while I'm alive and well. No problem there. Plan for disability. Makes sense. Then I want to give what I have to whom I want, when I want, in the way that I want. This is one of the ways you can leave your assets to your loved ones. Okay. Wow, I didn't know I could do that. Sure. And it didn't cost any different, right? And so you have to just understand how that works. And so basic idea, without getting into too much details, I use my little cup here. Think of your, and then I have to introduce you to the concept of a trust. A lot of people get confused. A trust is just a contract. And it's really the preferred method of estate planning now with the current laws. And the will is the antiquated way of doing things. Yeah, will, you can do it. And there's wills that support a good plan. But really the best plans that I've seen, the trusts are the centerpiece of the plan. And a trust is a contract where you're all three parties to the contract. You're the trust makers, you're creating it. You're the trustee who manages it. And you're the beneficiary of it. And so you're just building a succession plan so they don't have to go to court. Here's my rules, here's my court. And then I'm going to stack the deck in my favor. And a revocable trust, when you're looking at the creditor side of things, means you can get in and out of your trust and do whatever you want with it, and your creditors can. So do not leave here saying a revocable trust protects all my assets. It does not. It's a great estate planning vehicle, okay? It's a way to centralize management of your assets and pass on the wealth. But for you, a revocable trust is not going to give you asset protection. But when you die, you can put the lid over it and say, this is my hard-earned wealth for my beneficiaries. They can use the money, but not their ex-spouses, not their creditors. With their money, those creditors can take their money, but not my money, okay? You can do that under trust law, basic tenet of trust law. And that's powerful, okay? If you have something to protect, something to investigate. If you don't, that's not something that's important to you, then I've checked that box off for you, right? And the point of it is that someone is walking through these options with you to see what's important to you. Most of our clients really like that, okay? We just live in a litigious society these days. Divorce protection, I don't spend too much time on it. I just say, how would you like to assure that the assets that you leave to your beneficiaries stay with them, right? And don't go with the new outlaws. So that's divorce, but we can definitely do that. Values promotion, I use what's called my babysitter story. And so if you ever hired a babysitter or ever, been babysat, then basically, like for me, I have a 6-year-old daughter. I've got started late in life. And so when we were hiring our first babysitter, there's all these questions, right? All these instructions that we would leave. So we're going to be we're going to go to this restaurant. She's going to want to stay up late. If you read a book to her, you read every page, because if you skip a page, she knows. I don't know how she knows. She's not going to want to brush her teeth. Our neighbor's information is here. My cell phone is information there, right? So all these things that we're leaving instructions for our loved ones when they're little, when we're just going away for one evening, right? For a dinner and a show. And my point is simple, right? Do you agree that we leave more instructions then when we're just going away for one evening than we even think about leaving in our estate plans when we're going away for a lifetime? Okay. And so it's not something where I would say, here's a blank piece of paper, give me your values. We've done this before where you can there's certain places in the estate planning world where you can identify, record, and memorialize certain things that are important to you. And again, these are options. I don't force anybody. I just say, these are the best plans. Take what you want from them that works for your family, okay? And so that's the way I look at it, is kind of like the trip to the eye doctor. Which one do you like? I'll narrow down the options for you, like A or B. I never can guess, but the point of it is we'll narrow them down and we'll co-counsel the plan. I'm not going to force a plan on you, right? Every family is different and they have different goals. So that's what I mean by really doing counseling, is someone sitting down with you to understand your particular situation, okay? Once we've got that set up, okay, then let's maintain the plan, okay? And so early on in my career, I would focus on why you need to update your estate plan. And I think people get that. I think people get that now. I was focusing on, people just didn't want to pay the attorney to keep it updated. It's like, okay, focus on the money, Bobby. Don't focus on why. So your family, you're going to have changes in your personal situation. There's going to be changes in the law. I know that laws constantly change. There's been a slew of legislation change over the past 4 or 5 years that we've filtered through with our clients and updated the plans, because the Secure Act, which impacted every IRA, was not there prior to 2019. Okay, so if you have a plan before 2019 and doesn't have the magic language of the Secure Act, your plan is outdated. Okay, and so there's a Secure Act 2.0 coming out in Congress. So I don't know what, I mean, we have a guess what they're going to say, right? But it's going to change. And then the estate tax laws and the tax laws all get sunset in 2026. So it's always in flux with the laws. And then the attorneys learning, right? So my plans that were done in 2007, they were my best shot then, and they were good plans. But 2022, I'm an LLM now, conferences, I'm an instructor. It just gets tighter and tighter as the years go by, right? And so you keep getting better. And if you just be working on that attorney's best shot in that year, if it's never been updated. So how do we focus on the, I'll focus on the fees now. So we have a maintenance plan. Our maintenance plan is currently $875 a year annually. It's optional. Don't force anybody to do it. What do you get for that? I'm not going to nickel and dime you for a phone call. So for those of you who are talking about fees or focused on fees, that's one fee. That's the maintenance plan fee every year, $875, and it's optional. Phone calls, emails, faxes, letters, I'm not going to nickel and dime you. I hate that. Okay, copies, a word processing amendment, someone moves, name changes, we're going to update the plan as part of the deal. This next one is probably the most important thing, and I want to make sure you understand it, is annual funding double check and ongoing funding support. That alone is worth the $875 itself. Okay, I'll tell you right now, but let me show you why. So you have funding, attorneys drive me crazy. We have this terminology. Funding is about titling your assets. Okay, what does funding mean? It's basically just making sure assets are titled the right way. And if you have a trust, making sure that the assets are titled in the trust properly or to the trust properly. And the way we do it, okay, is part of our setup is a big part of it is not only doing the counseling and setting up the initial legal structure, but also coordinating and titling all your assets so your instructions actually apply. That is a common pitfall in estate planning is people are selling these documents. That's the lower end of it, right? If they've been counseled, great. The funding is the time-consuming, putting everything in, re-registering accounts, doing deeds, updating beneficiary designations, making sure that when something happens, we don't have to go to court. We got everything tight up front. That's what the big difference is, okay? And so, yes, we'll set up the plan up front, but we don't think you're going to live in a vacuum. And so if you buy and sell things, right, and move assets or asset values change, we got to make sure that we got that covered. And this report is huge because it cuts a tremendous amount of time and expense off of the administration of your estate. I don't have to play Sherlock Holmes to go find everything. I know that the Bank of America account is in the RLT, stands for Revocable Living Trust. I've got a check mark by it. Give me the new value. So every year we'll send you this out in our portal, upload it. Here, give us the new values of your assets. If you sold something, cross it out. If you bought something new, go ahead and add it over. Add it over here. And so the very important tool, very important report for us. And that's what I mean by, and if you buy something new or buy a new property or open up a new account, give us a call. We'll get it titled up front right off the bat. Makes it a lot easier. So ongoing funding support. Okay. Big deal. Family meeting is only in year one as part of the deal. If you want to do it in future meeting years, that's fine. There's going to be an additional fee for that. That's where we'll go over the plan as high level or as detailed as you want with whoever you want, okay? Because you're doing this typically for your family and they're gonna have to be dealing with it. So if they're at that time, they're at that age where they can handle this stuff and understand their roles and the like, I'm all for it, okay? Annual group client meeting. So there's no way, we've got about 300 families in our maintenance plan now. There's no way I'm doing 300 individual meetings and getting everything across, okay? We do group meetings on the annual client meetings, and I do them through Zoom, where on 3 to 4 different occasions where we have the live events, and they're also recorded, where I'm going over what's going on with the laws, what's going on with the law firm, what you need to be worried about or concerned about in the estate planning front. Okay, so it's a kind of a big picture shareholder meeting going over those issues, and we'll make sure that we have the latest and greatest of your assets updated to your portal. Every 3 years, we actually update your legal documents, okay? And we do it through a group document type of structure where we're able to facilitate updating the documents, not 1 or 2 clients at a time, but maybe 20 at a time. And we've done this a few times. For those of you who are out of state or not local to one of our hubs, then we have digital notary services, or there's certain special planning that we do for those clients that can't make it in, that we have on a case-by-case basis that we work out with regard to that. Because we have clients, Northern Virginia is a very transient area, and we have got clients in all, like, probably got clients in like 15, 16 different states. A lot of people seem to retire to Florida. God's waiting room, right? And so the idea is to be able to manage that and be able to keep the plans updated. With technology, we're getting there. A few years out where it's much more smooth, but yeah, I'm a digital notary. Ginny's a digital notary. We're able to notarize digitally, but the technology is a little bit clunky where I can't do it in group yet, but we can do it. And so it's just a matter of figuring out what works best for you and the firm with regard to that. We have group educational programs on different, topics. And so the main one that most people come to is required. I do it in the fall each year. You're required to come once every 5 years to that one. I call it the 911 program, what to do when a loved one becomes disabled, what to do when a loved one passes away. So I go through like the steps, the break the glass information. Here's the first 3 or 4 things you need to know, checklist, something happens, right? And the idea there is, let's educate people just, on the key stuff. You don't have to be an expert ahead of time, so that they're not clearly clueless. And when the death occurs, now they're stumbling into the attorney's office, right? Grieving one-on-one, clueless, right? Rather than, oh, they've got a process, talked about it, we've got things set up, go tell the attorney, we'll lay it out, right? DocuBank membership is like having online medical directives. So part of our portal, you'll have everything digitally on your portal, all your documents, but this is one where I think it's really a cool service and it's very valuable, is that it's like carrying your medical directives in your pocket at any time. So let me show you how quickly I could pull my medical directives off of the website. And so it just shows you, the value of technology and the like, because, if you get into an accident or something, you're not probably carrying your medical directives with you. And so the idea with these this DocuBank card is that people can find that DocuBank card, then they'll be able to actually get your directives rather than have to deal with the hospital forcing down directives down your throat. So our clients have a client dashboard, and it should show you very quickly how quickly you could access the medical directive. So we utilize, you get what's called a DocuBank card. I'll show you how it looks like. I'm going to show you the full login so you can see kind of the full value of everything. But you see how quickly the card looks like this. So everyone get a little card. I tell people, hey, sandwich that card between your driver's license and your health insurance card, because if you get into an accident, number one, they're going to want to know who you are. And number two, if you can pay. This card says, my directives are here. You can pull them offline if you want. There's an 800 number, call. It'll be emailed, fax, 365 days a year, 24 hours a day. And boom, I just print documents. And how long did that take me? I probably could have done it in 10 seconds. But these are my medical directives, okay? And so I like to show you this because there's also more capability to that, because you can also, like my dad, when he had the dementia, he was on like 6 or 7 different medications, right? And we were trying to figure out the dosages. Having it all in one place, the frequency, very nice service to have as well. And it's always nice to have a medical snapshot that's helpful for people as far as knowing who your doctors are, your conditions, or any vaccination histories and the like, okay? So very nice service, part of the deal, part of the maintenance plan. And so it's not just about the documents, it's taking it to, okay, someone is actually needing the directives, how does it work, and what are their wishes, right? Let's make it practical for you. Make sure that I'm sharing the screen. So that's it. So that's what I mean by the maintenance plan, giving you kind of an idea of how that works. So this is kind of reviewing that. The maintenance plan, I call it like the handshake. We're going to continuously commit to you all every year. The asset review report. The estate planning review worksheet is a little executive summary of your plan that allows us a way for you to just make the personal changes, and we put the legal updates. So that's another report. Those are the two main reports that we provide you. And so you look at those. I'll show you the estate planning review worksheet really quickly. It's just a nice little document that allows us to, hi, here's your trustees, here's your disability panel, any changes, yes or no, any specific distributions, any beneficiary changes, you want to cut someone out, you know, so your healthcare powers of attorneys, your disability trustees, your desk trustees. So very easy way to update your information, make changes. And so those are the two main reports that we have. Annual client meeting, we have the client update to update the documents every 3 years, and then education, we filter in on different topics. Like all this changes with the retirement plan information. I'm going to do, my clients say, hey, Bobby, you need to do 2 programs, one on cryptocurrency, one on Secure Act and IRAs and stuff. So we're working on those right now. Okay, so that's maintenance. Now, the last step is securing appropriate assistance for your family to transfer your wealth, wisdom along the rest of your wealth for your family, right? So how do we do that? So I don't know what appropriate assistance looks like to you, but for me and my clients, it's about controlling the cost, first of all, full disclosure of the cost, and hopefully that'll give you true peace of mind. All right, so let's talk about fees and costs and all that stuff. So how do you control costs in the estate planning world? Number one, we talked about this briefly, full funding, meaning titling all the assets in the right place. Why does that control cost? So if I have everything titled in the trust or payable to the trust, right, or some way that's not going to go through the probate process, then that will be less of administration for me if I don't have to go through probate, and that translates into a cost savings for the clients. If we don't have to do that and fill out all the courts forms and pleadings and all those things, that makes the job easier. Because if you do the trust route, which I see consistently, people create these trusts, but they don't do the funding, you leave one asset out, those assets go through the probate process, okay? It's an all or nothing deal, right? And so why'd you spend the money on the trust if you're not going to do the follow-up work? And so for us, it's just too important. So we manage that funding process. It's tedious, it's time consuming, it's a lost leader for us, but it's the right thing to do. And I'll show you how we do that, okay? And so give you some legal technical information for a lot of you who might see this out there if you've done some research. So there's what's called a pour over will. So as part of our planning, typically, you will get a revocable trust, but you will also get a pour over will, okay? So you will get a will. The pour over will, I call it a legal pooper scooper. It cleans up after your mess, okay? Because it says, for the stuff that I should have put in my trust during my lifetime, scoop it up after my death and pour it into my trust, right? So the good news is if you left stuff out, the pour over will catch it. The bad news is every asset that got left out will go through the probate process, okay? I mean, there's some exceptions if they're minor assets, but they're a pain, and so that's the way to go. So that's full funding, okay? And then that's controlling costs. The next one is proactive trustee and beneficiary training. So if the next people in line have some idea of the game plan, they don't need to be experts. Here's what your role is. Here's what you need to do. Here's who you call, right? Here's the process, follow it because we know it works. And so rather than moving stuff around, fighting the process and doing that. So as long as the beneficiaries or the trustees, the backups understand that controls costs and makes things go smoother. And then a proactive engagement approach. For us, if you're on our maintenance plan, we will agree to do the administration at predetermined rates, which are below market. Your family does not have to hire us. I can't ethically bind anybody to use us, okay? The successors would have to affirmatively hire us at that time. We'll be the cheapest people at that time, but that's the way that it would work on that end. I can't, some of my family's clients say, can we force them to use you? I can't do that. So those are ways to control the costs in the estate planning world. All right, so, and then the funding, I already explained that to you, is getting everything into the trust. Boom. One thing, I don't want you to leave here saying, oh, everything's got to go into trust. One major asset you never put into your trust, okay, at least for your own trust, okay, is your IRA, your 401k, any qualified retirement plans that are tax sheltered. If I were to put your IRA into your trust, the IRS considers that a distribution. Distributions are when taxes are due. We don't want that. I'm going to be helping you minimize taxes, okay? I don't want to add to your burden. So to me, that's one major asset we don't put in the trust. But the things that you think about with the IRAs are, okay, well, what if I become disabled? Well, let's make sure the power of attorney is approved by the financial custodian. And so that if you become disabled, they're going to say, oh, this power of attorney is outdated or it doesn't have our magic language. So we want to make sure they're going to honor the power of attorney if that time comes. And then there might be a way we might want to leave the IRA assets to a trust after you die. I'm not saying we do. I'm saying it may be. Depends on your situation, okay, and what the value of the IRAs are. But these are counseling game time calls, okay, that someone needs to talk you through when you're dealing with it. Full disclosure. All right, so full disclosure of cost. Now we'll talk about the fees. So these are ranges. I can't give you exact range until I know what your situation is, your specific goals, and how the financial picture looks now. I can tell you won't get charged anything until I know what we're doing and say, here's what we would charge. And you say, great. But here's an idea of the fees that we see. And then out there in the estate planning world. So you can see, what's going on. I'll tell you what's happening out there in the world. So there's 3 factors of every estate planning setup when you're estate plan. Number 1 is setting up the initial cost of the initial counseling and the documents, setting up the plan. Okay. Then there's a cost of updating the plan, or most people I find fail to update the plan. And then the third is the cost after death. Okay. People don't look at that. Everyone's focused here. They don't think here. That's where they're all back end loaded. So let me show you what the costs after death look like. Okay. And these are just the schedules. I just put Virginia, Maryland, and in here. Okay. Every state has their own. It just depends on, plug and play. But basically they're all about the same ranges. So this is if you went the probate route. Oh, I want the will-based plan. I want the family, go through probate. Here's the probate schedules. They're public schedules. You go down the probate court, they'll tell you, this is what the fiduciaries are entitled to for compensation. So typically what happens is, maybe if in a married couple situation, the spouse is the executor, right? They have no clue what to do. They hire an attorney. The hired attorneys charge these rates, right? Do all attorneys charge these rates? No, some will charge less, some will charge more. It depends on your situation. I find it rare that the attorneys will charge you less than the maximum that they can get, but your call. So while the assets are tied up in probate, any income that is generated, so if you have dividend paying stocks, 5% of those receipts are reasonable fee. If you had $1 million go through probate, the principal is $1 million. The first 400,000, 5% can be charged on that. The next 300,000, 4%. The next 300,000, 3%. Okay, that's Virginia. I love the part right here. The commissioner may increase or decrease the compensation depending on how out of whack the estate is and how unorganized it is. Loudoun's the same as Fairfax. All the Virginia counties are the same. It's just I like Fairfax as a nicer schedule. Maryland, Montgomery County, Maryland's all the same, but Montgomery County gives you kind of a clear way of showing it. So basically, Maryland says 3.6% of everything over 20 grand is a reasonable attorney fee. Okay. 9% on the first 20,000, but 3.6% over that. That's for things that are going through probate. Okay. Those are ranges for that. That's will. It's about, you're going to say, Bobby, I don't want the will. I like the trust. Trust is good. Okay. So let me show you, I give you Florida statutes for the trust. It's not because I think you go to Florida. The Florida statutes are here to teach you 2 things. The first teaching point is, number 1, people think that if they've done the trust, that's a great step for the family and they've actually funded it, that there's no other work to be done when you die. Okay. That's not true. Like the trust is not going to jump off the shelf and do everything. And you're like, what do you do? Right. I don't know how to convey this to you without actually going through administration. I've gone through 52 administrations with you, not with you, but 50 is death is a major life event. Okay. You need closure on every relationship you have. IRS, real estate, financial assets, online account, everything that you have, debts, expenses, bills, whatever, has to be wound up. Somebody has to do that. Okay. It does not happen magically. The trust helps if it's done right, that we're not on the court schedule, but there's an administration regardless. Okay. So that's one teaching point from this, is that there's a trustee attorney's fees on this. The purpose of this is showing you there's a limit, and I'm backing up a little bit, Florida is a very strong consumer protection state for seniors. Has a very strong senior lobby. Like I said before, it's kind of God's waiting room, right? And so the seniors there say, hey, you just drive into Florida, you'll see a big billboard for living trusts. Okay. So they're like the Mecca of living trusts. And so they got the legislature to basically say, hey, we're going to put a cap on what these attorneys can charge to do a trust administration. So this is just giving you a cap. And the reason why I put this Florida statute in is it gives you a good idea of what the market rate for a trust administration costs. That's a long-winded way of saying that, okay? Because there's just no other way to explain that. And so it's on a percentage of the estate, and it's paragraph 3. And I'll boil it down for you. You should have this in your materials. But basically, they're saying that an attorney can charge 75% of what they could have charged in a normal probate, and that's a reasonable fee for a trust. So you get a 25% discount for having the trust. Well, what are Florida's fees, right? Just to show you kind of what's out there in the world, Florida being the strongest in the consumer protection state. So it's kind of it's on a percentage scale. They're lower percentages, right? Instead of being at 5%, they're at 3% from between 100 and 900,000. They're at 2.5% between 1 and 3 million. So you get the idea. I can't give you a magic number. There's going to be an administration around 2 to 3%, maybe more, depending on how, if you had to go through probate and stuff like that. But you have to understand that's a real expense to your plan. All right, so how do we set our fees? Our fees are set like this. I'll give you ranges. So there's 2 options. Option 1, I'll start with the after death. So there's a setup, maintenance, and after death. So after death, we will agree, if you're on our option 1, to fix the administration expense at 1.25% on the size of the net estate, only if we're hired, and only payable at death after we're hired. So you just saw 2, 3, 4, 5%. We're going to be much lower because of this maintenance plan. Okay. And again, your family does not have to use this. Everyone does, but you don't have to. Okay. And so the maintenance plan, I told you about the $875 a year, right? The first year, the maintenance plan to enroll, we charge you $1,500. That's because to get all the assets into the trust that no one else is doing, the deeds, titling the investment accounts, re-registering those, updating beneficiary designations, all doing the tedious time-consuming work. And that's still a loss later, but it's the right thing, okay? And so that's important that you understand that that's what that is for. Year 1, enrolling and get everything funded. After that, that's the heavy lifting. To set up the whole plan, and that plan, most people ask, well, what is the setup? If this is for most people, if you don't have a taxable estate, and not many people have a taxable estate now. If you do, good for you. You get to do some advanced planning, but most people are not a taxable estate. And we'll talk a little bit about that. You have to have at least over $12 million on the federal level to have a taxable estate. If you live in a jurisdiction like Maryland or DC, they're one of the few states that have a state estate tax. They say, we don't care about the feds. You're getting the state tax at $5 million. Okay, so if you're at those ranges, then you may have a taxable estate. If not, then you'll have all the legal documents that you need, and typically are going to be the trusts and the counseling behind the trusts, the pour over will, right? The medical directives, the counseling behind that, the powers of attorneys. Those are the types of things that are part of that package. We charge 0.5% on the size of your net estate, subject to a minimum of $5K. Our maximum is $13,500. Where you land on there depends on what your goals are, what you're trying to accomplish, and what you're trying to do. Okay. Some people say that's too high for you, the first option. Let me do option 2. Option 2 is 1/3 of 1% on the size of your net estate. Our minimum is still $5K. Our maximum is $10K there. But the back end, we're going to charge you 2% rather than capping you at 1.25% on the size of the administration. So it's up to you which option you take. And, to me, I don't care which option you take, that you understand why the options are there. And when someone says they're going to sell you a trust for $2,000, what are you getting for that, right? Are they going to title the asset properly? Are they going to counsel you on that? Are they going to go through the healthcare counseling and the disability options that are there? Or what are you getting, right? So you get what you pay for on that. And so those are the options there. 2 questions you should be asking me. You probably would, but you're muted, or you can type it in, or tell me later, or you're just being nice. One is, what if something happens to you, Bobby? Right? I have more people worried about my health and welfare than I've had in my life. And so I would not be a good estate planning attorney if I did not have a good succession plan in place. And so In the bio packet, Ed Clay is part of the bio packet. He's my backup attorney. He teaches with me at the National Network of Estate Planning Attorneys. He's my external succession plan for now. He's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his. Until my internal succession plan, which I'm working on now, and it should be pretty much finalized within the next 5 years, is all set, where my junior associates are coming in and going through and taking over on that. I'm not going anywhere that I'm planning, right? This is what I love to do. This is my area of law. I've spent my whole life dedicated to this, but that's my backup plan. And the way that we have our model, this is my business model here. I'm just showing you. It provides for that stability because I have these residuals coming in on the maintenance plan that will help pay for the team members' positions, and it reduces the stress for the attorneys to worry about cash flow. They're going to have a position here, and we want them to work the client's plans, be able to update and maintain our clients' plans, right? And it's very predictable, the settlement and administration revenue, because everyone usually hires us with regard to it. So it's pretty predictable. I don't know when my clients are going to pass away, but I know they usually typically will hire us at that time. They don't have to, but they do. And that's it's very attractive for other attorneys for a succession plan, because I get asked by more senior attorneys than me to buy their practices, and I've yet to buy any of their practices, because once I look at their files, I see that nothing has been funded. I see there's no relationship with the family. I see they did some documents for them, and it was very quick, and there was no follow-up, no follow-through. And so they basically want to unload all their problems. So when there's a death that occurs and everything's a mess, they want me to try to pick up the pieces. No, thank you. Okay, I don't want to. Our process, very quiet in our office. We have a very specific. We're not fire drills. We just pushing papers. We know where to go. We've done this enough times where we've got a good plan with regard to it. The initial counseling and design, we're not looking to bring in thousands of clients. Our goal is to bring in 60 clients this year. We're not what's called, I call them Will Mills, where they just try to crank out volume and there's no follow-up. Less clients, more preparation, more detail work, and more follow-up. Okay, not necessarily just less client. I don't want many clients like that. And so that's our business model right there. Hopefully that is helpful for you all. So then the rest of it, so I would ask the attorney, okay, what are the rest of fees? If you're cost me for setup for this, how much are you going to charge me for funding? How much are you going to charge my family to administer the estate, right? And they say, I can't tell you. Say, here's my assets. I die tomorrow. What are you going to charge my family? You're probably not going to like what they're going to say on that. Are you going to charge my family for a death tax return if that's necessary, right? And that's becoming more and more necessary with this concept called portability, which is beyond the scope today. But that's part of our fee. There's no hidden agenda or fee. That's it. What I showed you, that is it. And this is my trick question for attorneys is ask them how much they charge for probate services on their trust-based plans. It's a trick question, right? If they have a lot of their trust-based plans going through probate, that should be a red flag to you, right? That means why is their plans going? They shouldn't be going through probate. So we've had to go through probate on one of our plans that was a foreign asset that wasn't disclosed to us. It really made me mad because I had a perfect probate record. But the idea is that we want to avoid that. In my mind, I just find it just slows things down, and it's like it's unnecessary if you do it right. So the big picture costs after death. Remember those probate schedules I gave you to you? Anywhere from 2.5% to 5% of your estate, depending on the size of your estate. The standard living trust planning is those Florida schedules I gave you to you with that 25% discount. Ours is around 1% to 2% for the life of the plan. Okay, so it's one of those things that it happens to be lower if you look at the whole picture, and it actually works, which is the real thing. Is people just want the plan to work and make it smooth for their family. That gives you hopefully true peace of mind. Where am I at? 110. Okay, so that's pretty much the presentation. So kind of summary items here. There is traditional planning, and then there's the modern approach that I've been kind of going through with you. The traditional planning, you get some basic documents and questions answered. The modern approach is so much more, right? We talked about the counseling, the funding, the maintenance, the updating, education, disability events, surviving spouse having to deal with stuff, and settlement. So that is it. The next steps, I'll show you my process chart. I just find process produces predictable results in our field. And so the process chart is this. We're here. It's with me. There's no charge. It's about an hour to an hour and a half, right? Depending on the issues. I'll open it up to questions in a minute. And then if you are interested in exploring further, you can ask for a discovery meeting, and Michelle will get you scheduled. The discovery meeting is no charge. It'll be with Wendy. She will do a goal setting exercise with you. She'll review your personal information form and give you some fee ranges. Okay. And if you know what you're going to do, she'll have engagement agreements ready to go. You need to think about it. Then the initial interview, the initial interview is my little stop sign where we go over the exact engagement agreements, specific fee quote, scope of services. Is this a good fit or not? If we say yes, it looks good, then half of the fee is due once we engage and before the design meeting, and half at when we deliver the legal documents and the like. And so the design meeting is usually 2 to 4 hours. I would never keep you in a room for 4 hours or do the Zoom for 4 hours. 2 hours is usually the max per session. If we need to do 2 sessions, fine. It's no problem. We're not going to charge you extra for that. Usually we can do it in 1 session. And then the delivery and review meeting is where we review the legal documents with you, make sure you understand them, witness them, formalize, make them legal, right? Answer any questions that you have. That's usually 2 to 3 hours as well. And then the financial strategy meeting is where we look at all of your assets and make sure we have an accurate inventory of your assets. And then we make recommendations on how to title your assets. And once everyone signs off on it and says, yep, this looks good, then we will fund the plan. We will do the funding meeting. Jenny Oliver, our funding coordinator, will have all of the assets, all the magic documents for you to sign to get everything in the right place. Okay, not an easy task to do. And then there's an optional family meeting where we'll go over the plan as high level or as detailed as you want with whoever you want. No additional charge as long as it's done within 1 year of signing the plan. And then you're just on maintenance. So the heavy lifting is up front and then you're on maintenance. So people also often ask me, how long does it take to go through the process? You'd have if you were like, I want to go, I'm ready to go today, and you were scheduling your discovery dialogue, within 6 to 8 weeks, you'd have the legal documents in your hand. Okay. The funding takes a little bit longer because we're dealing with courts and land records or financial institutions, but the legal structure will be in place. And then the funding takes a little bit longer, but we have milestones on that 30-day call, 60-day call, and usually wiped out by 90 days. We have all the funding issues covered. So that's our process. You're right here, right now. I think that was all the items that we will do. And so that is it. Let me see how I did on the selecting and working with an estate planning sheet. So this is what I would be asking. So like I told you before, the reason why I asked question 1 is be wary. I mean, this is all we do. Be careful to having someone who's doing a jack of all trades doing your estate plan. How do you define your estate plan? Remember the estate planning definition: control while healthy, alive, disability plan, and then give what I have to whom I want, when I want, and the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. Counseling philosophy, that's that pyramid that's out there that goes through first to figure out what your situation is and the family dynamics, then provide recommendations. Going through my process chart with you. How will you counsel with me? I mean, this is what you get. I tell visual stories, and I tell stories and give visuals. And then how do we ensure my assets are controlled by my instructions? That's the funding one. That's an important one, right? That's the one that distinguishes us from a lot of firms too. Who's responsible for this coordination? You or me? We coordinate all that. Okay. How do we assure my plan stays current? That's our maintenance plan. What's the level of involvement of my family in the planning process? I mean, I'm a believer that more is better, but every family is different. So we just got to figure that out. How do you charge for services? How much will my estate be charged after I'm gone, right? What's your record with regard to probate? I had that one loss, but it wasn't really our fault, but I would want to ask them that, right? Do you handle the filing the death tax returns? Yes, we do that. What happens if something happens to you? My succession plan. How do I prepare for our consultation? Just fill out the personal information form that Michelle gives you. And then the service, what type of service should I expect from you? I'm a big believer in team. So everyone in our team has a great role. Ginny's a star at funding. Michelle's great with coordinating assets. Wendy's great with drafting a lot of the trust. I'm great with the design. Wendy's great with the design too. So everyone's got a different role with regard to it. And I just find you have a better plan when you have people more than just one person being bottlenecked, right? And then you expect any commitments from me, just complete the personal information form, respect our process. Things that you should be thinking about are, what are your planning goals? So, you know, maybe some of the things you thought about, maybe disability planning is important to me, or maybe the creditor protection is important, right? And then who will fulfill the necessary helper roles? Our goal is to help you with that, but come up with candidates. Like a good healthcare agent is someone who will ask the doctor the tough questions and honor your wishes, right? Not necessarily the same person who would be a trustee dealing with financial investments and assets, different qualities usually there. Do you have a current inventory of assets? Assets are really important, right? We're dealing with transferring them in the most seamless way possible. And then if you have a financial advisor, those are great people to involve in the plan if you have one with regard to it. So that's it. That's all I got. If anybody wants to ask any questions, they can, or unmute themselves, that's fine. I'll hang out for about another minute and then I will conclude. So thank you all very much. This has been Bobby Fazy, president of Insight Law, teaching you a little bit about estate planning on a Friday afternoon. Hopefully everyone has a good weekend. All right, I will go ahead and conclude. Thank you very much. Or did someone have a question?
No, just wanted to say thank you. That was very informative.
You're welcome. Thank you, Lori. All right.
I had a question.
Yes.
Is there a separate fee for both spouses?
No, it's per family, husband and wife.
Okay. Thank you.
You're welcome. All right. Have a good weekend, everyone. Thank you.